wenn die alle oder viele von denen da sind.
Ja, ja.
Das heißt, ich drehe es auch auf jetzt.
Ihr könnt es auch aufdrehen, wenn ihr wollt. Ja, genau. Ja, super. So, good evening, everyone. Welcome to this Peaceful Change, ÖFG Peaceful Change panel discussion. Panel discussions are always particularly nice because you don't have to listen to just one speaker who goes on and on about for 45 minutes or longer. But you have two, and there will be a lot of discussion amongst the three of us, between you and us. And so I'm really looking forward to this. The topic is intercultural dimensions of international law. So me not being an international lawyer, I don't know all that much about it. Just a few introductory remarks how I see that. This working group at the Austrian Research Association that we have is entitled Peaceful Change. It's been ongoing for 6 years. And that term is very much in fashion at the moment in international relations as a discipline. Yeah, it's a question about world order, changes, do they happen violently, do they happen peacefully, under what conditions do we have what kind of avenue of change? Originally, this actually comes from international law. So it's E.H. Carr, international relations scholar, but originally an international lawyer. And he was very much interested in the peaceful settlement of disputes. And when we look at the peaceful settlement of disputes now, then on the one hand, at least to me as an IR scholar, it looks very clear-cut. So I look at Chapter 6 of the UN Charter, and there's all kinds of things written in there that states are obligated to seek peaceful settlement of disputes, and there are all kinds of methods that are being listed. But there's also something a very general provision that states can basically settle these disputes with all kinds of means, so it's not an exhaustive list. And when we look at how different states in different regions of the world settle disputes, it's oftentimes quite different, or how internal conflicts get settled is oftentimes quite different. So you see where I'm hinting at. I'm hinting more and more at the topic of today's talk, intercultural dimensions of international law. And please join me in welcoming our two speakers for today. And even before I introduce them, we can give them a big round of applause. There's to my right, Professor Rüdiger Lohlker. He's Professor of Islamic Studies. He's currently working as Professorial Research Fellow at the Research Center Religion and Transformation in Contemporary Society at the University of Vienna. So it's another non-international lawyer sitting there to my right. And he does very exciting research on the theory of rulership in Islam, Islamic law, Indonesian Islam, Islamic soft power, and Islamic extremism. And his recent publications include Humanitarian Islam, 2023, Agents of Violence, 2024, and Geschichte des islamischen Denkens über Herrschaft, so the history of Islamic thought about rule, which is, I think, forthcoming soon.
Hopefully.
Yes, hopefully. And to my left is Professor Irmgard Marboe. She's Professor of International Law at the Department of European, International and Comparative Law at the Faculty of Law at the University of Vienna. She is, by the way, also in the steering committee of our working group on peaceful change at the Austrian Research Association. And Irmgard, thanks a lot for your work in that context too. She was previously the director of the Vienna International Christian Islamic Summer University, which took place between 2008 and 2018 at the Abbey of Altenburg in Lower Austria. Between 2013 and 2018, she was co-rapporteur of the committee Islam and International Law of the International Law Association. And Irmgard also publishes widely, so for instance, her piece of Rule of Law, Freedom of Expression and Islamic Law in 2017. She's published a commentary on the Arab Charter and Human Rights in the Elgar Encyclopedia on Human Rights. And she published in the Proceedings of the German Society of International Law in 2024 on the topic Islamic Law and the Colonial Past from the Perspective of Public International Law. And discussing the order of things today, so we thought we'll let Irmgard go first, and she's gonna move probably from a more nuts and bolts understanding of international law towards the intercultural dimensions, and then Rüdiger is gonna follow up with that and is gonna focus a little more on what he does in terms of his research right now. So then, without any further ado, Irmgard, you start.
Thank you very much for this very kind introduction. It's a great pleasure to be here with you today, this evening, and this full house. Welcome. I'm really impressed and look forward to the discussion also. So I will not talk more than for 15 minutes, that we have also then time for discussion. I'm really curious to hear your views on your questions. Why I sent you this, a little list of last publications. They are specifically dealing with Islam and international law, because this is one of my specializations. But I've been here invited as previously on other areas, so that's why I explained that. I was invited for space law law of outer space is my other specialty, and international investment law. So very different areas, but I really like this change. Peaceful change amongst the disciplines. So Islam and international law. So I have worked a lot for many years on this relationship. So cultural dimensions of international law, in that sense, is occupying me for quite some time. On the other hand, when I read this title, I was wondering, how can you really reconcile culture, intercultural dimension, and law, when we think of law as an objective order of norms. So norms should be objective and should apply to everyone regardless of any cultural identity or background. Should not exactly law or justice be blind for these external influences. When we think of the goddess Justitia, Lady Justice, the Roman goddess, how she is depicted blindfolded, and she carries a balance in one hand for the careful weighing of all facts, and then the sword on the other for the enforcement of the law, but blindfolded that the law should apply equally to everyone. So how does that match with intercultural and different cultures? In particular then now when we talk about international law, and we know that at the international level we are faced with many different cultures, different systems, policies, ideologies, and how can this work together? Can it at all work? And I try to take out 3 principles of international law, as we call them, foundational principles of international relations, and they appear in the Friendly Relations Declaration of the United Nations of 1970, and the 3 of them are: first, the sovereign equality of states. So we talk about states. International law is about relations among states, and they should be sovereign and equal, and the principle of non-intervention goes with that. The second is the territorial integrity and the prohibition of the use of force. And the third is international human rights law, so that international relations should also be based on the respect for and the promotion of human rights. So first, I tried really to be brief, and it's such a huge subject, and of course we could write books on that. But I think this sovereign equality of states is called the classical system of international law. It's called the Westphalian system, started with 1648, with the end of the 30 Years' War in Europe, which was a religious war between Catholics and Protestant rulers for 30 years, and even part of the 100 Years' War also, mainly in Europe, and struggling with religious differences and ideologies and cultures, as we can say, Catholic and Protestant culture. And the result was the Westphalian peace treaties of 1648 of Münster and Osnabrück, and they were so famous for founding this new system of sovereign equalities of states with this acceptance that they are all equal and no one should interfere in the internal affairs of the other. So they should not have mainly religious reasons to intervene and to try to convert or try whatever to exercise their power to enlarge their Christian beliefs in the different areas of Germany, France, it was Sweden and Netherlands and Spain and Austria, of course, the big Habsburg Empire on the Catholic side. So, and for us in Europe, I think this was a really an important moment in time and is today, until today, accepted as a very foundational principle of international law. So all states are equal and non-interference. We should not take the ideology or culture or religion as a reason to intervene. And I just want to mention the Henry Kissinger's book, The World Order of 2014, who over hundreds of pages explains how important that principle is and how it can lead to peace if you say we don't intervene, we respect your different cultures. However, I have also read a lot of criticism of the Westphalian myth, yeah, the Westphalian system, what myth? Okay, but just to mention this term and this principle and how important it is. The second, the threat or use of force took much longer to be accepted until really much longer it was regarded as a natural right of a state to wage war, to use military force, to pursue its interest. And actually it took 2 world wars until in only 1945 in the UN Charter, the prohibition of the use of force against the states was accepted. And so this reinforces this principle of non-intervention with, and also with this the self-determination of people also, so that they can decide on their own cultural, social, political, and economic system. This sort of brings us then now to 45, to the 20th century, which was then the third area which I would like to discuss, the beginning of international human rights law. Until that time, human rights were only regarded as national domain. So how the states treated their own people was their own business. They may have constitutions which grant citizens civil rights, political rights, or other rights, but it was not on the international level. Only after 45 it started, and the first step, of course, was 1948, the Universal Declaration of Human Rights. And so this interesting thing is there was apparently an agreement of an international standard of human rights. Despite so many different countries and cultures, we do not anymore only talk about European countries like in the 17th century as the Westphalian peace, but we talk about universal agreement on human rights, despite so many different cultures. And this is, of course, always a very remarkable, and is it really true, and what did the states at that time really have in mind? Did they really agree? And this question now put me to look at a bit to the history of real how it was adopted, because it was not adopted by consensus, even though this is sometimes said it was consensus in a way. Yes, no state voted against. So and in that sense, yeah, we had. But there was a vote. It was not adopted by consensus, but there was a vote of 56 states at that time, not 193 as today, but 56 states of the United Nations at that time in 48 voted. No against, okay, because it was at the times regarded as, let's say, inconvenient to really vote against and would have isolated states diplomatically. So what we have is 48 states in favor and 8 abstentions. So of course then I looked who, what, and why 8 abstentions. So we have, and this then brings me now, and my focus of Islam was Saudi Arabia, but not only Saudi Arabia, but also South Africa for the racial discrimination there, and the Soviet Union and 5 socialist countries, Belarus, Czechoslovakia, Poland, Ukraine, Yugoslavia. They also abstained because they found it was too much focus on political and civil rights and not enough economic and social rights. And it was too much emphasis on individual freedoms, so to say. But they did not vote against. And Saudi Arabia, and now I continue with Islamic states, which is my focus, and also Professor Lohlker has expertise on that. So Saudi Arabia abstained. Why? Mainly because Article 16 on the right to marry without restrictions of religion. Then it was Article 18 on the freedom of religion, which contradicted Islamic principles to change one's religion, and several references to equality between men and women. Okay, so this was an abstention. But now, what is interesting, we had 7 Islamic states in favor, which were Afghanistan, so they voted in favor of the Universal Declaration. Afghanistan, Egypt, Iran, Iraq, Pakistan, Syria, and Turkey. And now it is interesting to see how these states later approached the UN human rights developments, mainly the covenants, treaties which followed afterwards. And I looked only on 4 of the several UN treaties: the ICCPR, the International Covenant on Civil and Political Rights, the ICESCR, the International Covenant on Economic, Social, and Cultural Rights, and CEDAW, the Convention Against All Forms of Discrimination Against Women, and the CRC, the Convention on the Rights of the Child. So the very, very prominent 4 core human rights treaties. And what do we see here? I have made this table exactly for this, and I really like the outcome. So all of these 7 states have ratified all of these 4 treaties, have ratified them, with the exception of Iran, that has only not ratified CEDAW, but it has ratified the other first covenants and the rights of the child. And what did they do? Did they, ratify them without any reservation or anything? No, they made reservations or declarations. And it's interesting, there's a great database to look at those reservations. And I just would like to share with you the Egypt declaration or reservations which they made with respect to Sharia and Islamic culture. And does that fit? Do the covenants and the treaties on human rights really fit these 4? And just for the first 2 UN covenants, Egypt declared, taking into consideration the provisions of the Islamic Sharia and the fact that they do not conflict with the text annexed to the instrument, we accept, support, and ratify it. This is the declaration. In 1982, when they ratified the covenants. However, almost at the same time, in 1981, even 1 year earlier, with respect to the CEDAW, the Women's Convention, Rights of Women Convention, they made a very long, specific reservation. And they explained why. That's interesting to read, and allow me to quote just this reservation, because other states like Iraq and other had rather general Sharia reservations, reading like, for example, the government of the Islamic Republic of Iran with the CRC reserves the right not to apply any provisions of articles of the convention that are incompatible with Islamic laws and the international legislation in effect. So rather general Sharia reservations, which really are problematic because we do not really know what does that mean. So they ratify the convention, for example, on the rights of the child, but on the other hand said, but only to the extent that it doesn't contradict Islamic law or our national law. But Egypt is very explicit and explains us more in detail, and this is the only example I will take out, but it's a very good example, I think. So, reservation to the text of Article 16 on the CEDAW concerning the equality of men and women in all matters relating to marriage and family relations during the marriage and upon its dissolution, without prejudice to the Islamic Sharia's provisions, whereby women are accorded rights equivalent to those of their spouses, so as to ensure a just balance between them. This is out of respect for the sacrosanct nature of the firm religious beliefs which govern marital relations in Egypt, and which may not be called in question, and in view of the fact that one of the most important bases of these relations is an equivalency of rights and duties, so as to ensure complementarity which guarantees true equality between the spouses. The provisions of the Sharia lay down that the husband shall pay bridal money to the wife and maintain her fully, and shall also make a payment to her upon divorce, whereas the wife retains full rights over her property and is not obliged to spend anything on her keep. The Sharia therefore restricts the wife's right to divorce by making it contingent on the judge's ruling, whereas no such restriction is laid down in the case of the husband. So this is very specific why they make this reservation on marriage. However, if that were the only reservation, we had no problem, but there is an additional general reservation on Article 2, namely, the Arab Republic of Egypt is willing to comply with the content of this article, provided that such compliance does not run counter to the Islamic Sharia. So this sounds very much to the general Sharia reservations. And Article 2 of the CEDAW is rather fundamental, because it says, well, the state parties condemn discrimination against women in all its forms, agree to pursue by all appropriate means and without delay a policy of eliminating discrimination against women, and to this end undertake, amongst others, to embody the principle of the equality of men and women in their national constitutions or other appropriate legislation, if not yet incorporated therein, and to ensure through law and other appropriate means the practical realization of this principle. So there we have an Egyptian reservation. So you see what we see from this and other similar reservations, that we have two approaches. On the one hand, the state says, well, there is no contradiction with human rights, international human rights, but on the other hand, with respect to women or freedom of religion, reservations have been considered as necessary. So as a result, my last minutes have started. I would like to highlight two documents which have been now then developed later on, a response from the Islamic realm to formulate specific Islamic human rights. And the first is the Cairo Declaration of Human Rights in Islam. First, it was published and adopted in 1990. Recently, in 2020, they had a reform project and now have a reformed version of the Cairo Declaration, and is an Islamic response to the United Nations Universal Declaration of Human Rights. And it contains numerous human rights which sound similar to the Universal Declaration, but almost all of them are restricted by the limits set by the principles of Islam and national legislation. Article 25 now, in the new version, reads, everyone has the right to exercise and enjoy the rights and freedoms set out in the present declaration without prejudice to the principles of Islam and national legislation. So we have a very general, limitation. Because of these limitations, this Cairo Declaration has been criticized as an attempt to shield OIC member states, because it's an OIC document, Organization of Islamic Cooperation, which has 57 member states and is really the biggest, second biggest after actually the United Nations organization to bring together Islamic, not only mainly majority countries, but some also minority countries, but mainly majority countries. And to, what do they say, they are the collective voice of the Muslim world and work to safeguard and protect the interests of the Muslim world in the spirit of promoting international peace and harmony. So that's the OIC document, and the Arab Charter of Human Rights is a document of the League of Arab States. It's not an Islamic really document, but it's concentrating on Arab states and the furthering of Arabic friendly relations and strengthen their cooperation. And it has now, the text is of 2004, and it's a charter, so a treaty is not only a declaration, and it's regarded or can be characterized as a comprehensive regional human rights documents like the European Convention on Human Rights. So we have these regional specific documents, and here the Arab Charter on Human Rights, which attempts to reconcile a modern understanding of human rights with the Arabic heritage and Islamic tradition. However, what we see in the reality, and also this is the criticism on both documents, that Islamic Sharia is interpreted in the different member states in a different terms and ways. We have Sunni, Shia Islam, and some more strict interpretations and more liberal interpretations in different countries. So what would be really urgently needed are monitoring bodies, and there are some monitoring bodies, the Arab Human Rights Committee, and there is also for the OIC an independent permanent human rights commission, which have the role of monitoring compliance with the declarations, but not in the sense that we know them from the Geneva organs, from the United Nations or the Strasbourg institutions for Europe. So this is the lack of monitoring and compliance, perhaps by independent bodies, is one of the problematic things we can see here. But further things perhaps for the discussion. My concluding word is, what do we have a conclusion? Does it work or not on the international level to protect human rights? And I would really like always to quote Manfred Nowak, who was a professor, is still a professor, but now emeritus of the University of Vienna, specialized in human rights, and was himself a special rapporteur, a UN rapporteur on torture. And he coined the term the art of human rights. And that there is an art of human rights, and emphasizing that international human rights norms always allow for adaptation to cultural specificities, because hardly any human right is absolute, without exceptions. So only a handful of the prohibition of torture, slavery, the inner side of freedom of thought or religion, but others, all others allow for limitations, but only under certain conditions. And this is sort of common of the documents. They need first a legitimate public purpose, so public order, public safety, public health, but also public morals, or the protection of the rights of others. Then the restrictions must be made by law. So important is there is a law of general application. It is not a selective case, an arbitrary application and limitation. It must be a general law that prescribes the limitations. And then the proportional limitation in relation to the purpose is important, that the limitation of the right should only go as far as necessary and useful to achieve the goal. And so with this tool, the public purposes, they are defined by the states and by the society that lives there. So it is possible and to adapt those, and these societies are changing and evolving, so that the human rights instruments are, of course, living instruments. Thank you very much.
Irmgard, thanks a lot. There's already a lot of fodder for thought, yeah, and think about the times that we are living in. So in many ways, human rights become more contested, and so we can ask Irmgard a lot of questions thereafter. But before that, let's move to Rüdiger, and I think he's going to continue quite a bit actually what Irmgard was talking about.
Okay, hopefully it may be a kind of continuation. I'll try. At least I have to focus on what has been mentioned, on the self-determination of the largest Muslim country in the world still. The Pakistanis are struggling to become larger, but yet they didn't succeed. At least I have to talk about Indonesia. And one of the largest organization worldwide, the largest Muslim organization. Okay, we're talking about, let's say, 90 to 95 million, only a small one, that may be regarded as very important. And I will refer first to a very short history of the recent development. And then maybe we'll join hands when talking about the international consensus and things like that. And about reservations of other Islamic countries. That's, I think, the most important stuff we have to talk about. Let me start with a short story. Many years ago, I don't remember, 2015 or something like that, I've been to Indonesia. We had a meeting at the Ministry of Religious Affairs in Jakarta. Okay, a lot of small talk. I was not listening, I have to admit. After 5 minutes, just looking around, seeing if something is interesting, and I saw the flag of the Ministry of Religious Affairs of the largest Muslim country, and down at the bottom of the flag there was a snake. That's the cosmic snake, the Ouroboros. Quite a Hindu idea. And as a professor of Islamic studies, I tried not to show my astonishment. Okay, why do you have a Hindu symbol in this ministry? But after we left, a lot of talk, let's talk, let's say, half an hour or so. The minister has to leave, and we happily enough could leave. I asked my friends, okay, what about that one? The snake over there. You are an Islamic country. What does it tell you? Oh, quite simple. My colleague said, it's our tradition, our cultural tradition. It's quite normal to have it. And it's similar like 2 years ago we had an international meeting, and it was offered to the participants to visit a Buddhist temple mount. The meeting was organized by the world's largest organization, the Nahdlatul Ulama. I will shorten it to, abbreviate it to NU, not to bother you with the whole name. And they invited us to this temple mount to visit it, a Buddhist temple mount. Okay, quite normal. An Islamic organization inviting their guests to a Buddhist temple mount. Really? Okay, it's great. It's a little bit challenging to climb up all the levels of this mount. And I won't continue these visits I had to several different religious places all over Indonesia. But it's okay, that's again, we are coming to culture. From an Indonesian point of view, non-Islamic cultures are part of the tradition. Indonesia, the archipelago, has been ruled by Hindu rulers, by Buddhist rulers, 20th century by Christians due to colonialism. We do have a very rich, diverse history of Indonesia, and it may be symbolized by the motto of the Indonesian Republic, saying, unity out of diversity. Not in Arabic, not in whatever Islamic language there may be, but in Sanskrit. That's about the short one about Indonesian culture. And we've heard about the reservations of Islamic/Arabic countries. And in the 1980s, there was a development started as the Indonesian big Islamic organization, not only the NU, the largest one, the smaller one, only 40 million members by now. The Muhammadiyah noticed there's a huge influence by Arab extremist movements supported by Arab governments in our country. And they are trying to hijack our Islam by this kind of point of view, from a point of view that's supported by Arab countries, by Saudi Arabia. It has been mentioned by others, for instance, by the Muslim Brotherhood and so on and so on. And they decided we have to counter this kind of these influences. And they decided to do research about the influence. Nobody knew about it. And they noticed, there's this subterranean attempt to turn our Indonesian traditions into Arab influenced traditions. Okay, maybe it's quite normal, but at least they decided to fight against. And again, tradition, they started from the experience 300 years ago when extremist Islamic influences manifested itself in Indonesia. And they said, okay, we have a long history of fighting extremism. Let's continue. That's continuation. And yep, and to jump to the 2000s and to bring Austria into the story, we were running a project with Indonesian friends, trying to understand the extremist terrorist organizations like IS. Nobody understood what these guys, what they are doing to our Islam. We have to do something, explain it to us, okay? And you need the Europeans, evidently, to do it. We have been over there talking a lot, trying to explain, and that's the reason the Indonesian organization of NU decided we have to quote a leading scholar at a meeting of around 5,000 religious scholars. We have a problem with our Islamic law. I'm quoting verbally. And I never heard something like that in the Arabic country. Nobody would dare to tell you that, but it's possible over there. And it's a discussion started. Okay, there are some misconceptions about Islamic law, especially in 2003, a big youth organization decided, okay, skip this idea of infidel, kafir, in Arabic. We don't need it anymore. We don't. What about infidels? Okay, no, we don't need it. Interestingly, the Indonesian president of that time was called an infidel, because he said, okay, we have to support democracy, the nation state of Indonesia, etc., and he was called infidel. And his reaction was quite simple, saying, okay, I've done something right. If they are calling me infidel, okay, I'm right. Let's continue. And, okay, the backing of the Indonesian president, and the largest Islamic organization, they started to look into the Islamic traditions. And they decided there are some problems, there are some misconceptions, some non-acceptable parts of our Islamic tradition, of Islamic law. We have to change it. Simply saying, okay, let's change it. And they started on it to cut it down a little bit. Don't be afraid. I like telling stories, but okay, I have to restrict my time. The NU decided we have to stick to the international consensus. Sharia, Islamic law, has to stick to the post-war, I'm quoting the General Secretary of the NU, to the post-war international consensus that constitutes, in terms of Islamic law, a valid transaction. And contracts have to be accepted, pacta sunt servanda. That's quite a principle we have to follow. And thus, okay, the Charter of the UN and the UN Convention on Human Rights are acceptable on the basis of Islamic law, since they are accepted by us and acceptable globally. Treaties we have to follow. Simply, okay, there are contracts we have to abide. Simple idea. Skip the infidels, things like that, and turn to that one. And we had, jumping to 2022, a conference, the G20 conference at Bali in Indonesia, headed by the Indonesian Republic. and they decided to establish a religious part of the G20 called R20, Religion 20. And interestingly, they co-organized this event, the NU and the Muslim World League of Saudi Arabia. Some very complicated stuff, but at least they succeeded. And okay, the NU told the gathering at Bali, okay, there is a treaty in Islamic history concluded by the Prophet Muhammad himself, called Hudaybiyah, to forget it about, but at least the Prophet himself decided to have a treaty respecting religious minorities. And who are you guys, you extremists, coming up with the ideas of minorities have to be subdued and have to be ruled by Muslims and don't have a right to follow their own traditions? Nope. That's okay. The Saudi participant of the roundtable didn't say anything concerning that one. Okay, that's another one. But at least to continue, in February 2023, Nahdlatul Ulama hosted the first International Convention on Islamic Jurisprudence for a Global Civilization, a very lengthy title, but at least they posed 70 questions to the leading Islamic scholars from around the world. Even the General Secretary of the Muslim World League from Saudi Arabia didn't attend. He was afraid. He would hear something he couldn't accept. But at least one of the questions was, is the UN Charter legitimate from a Sharia point of view? That's Islamic law point of view. Is it legally binding upon the nations that have agreed to abide by the UN Charter and upon the inhabitants, including Muslims that dwell in these nations? And okay, 300 is leading Islamic scholars. They simply said yes. Okay, we have to accept the UN Charter. Simply, okay, if we want. If we are doing a valid transaction, we have to follow it. Okay, there are other aspects. At least last year, in February again, 100 years centenary of Nahdlatul Ulama, there was a gathering of small group, only 2 million attendance of this meeting. Even the Indonesian president couldn't get through to hold a speech. He has to do it somewhere from the crowd. At least I was lucky enough very early there. I was closer than the Indonesian president. But this huge gathering decided we have to follow, okay, we have to say Islamic law, in our Indonesian perspective, has to follow the laws of international UN humanitarian law. Period. That's all. Okay, we do have a starting point to think about this kind of about the question how to integrate Islamic law into the framework of international law. And the Indonesians quite simply say, okay, it's possible, let's do it. We can talk a lot about whatever intricacies of Islamic law. I can do it myself, I've been teaching a lot. But at least it's quite simple. We have to change, let's say, the way we are playing the game. We are not talking about reservations. We are not talking about whatever small parts of Islamic status law, whatever it is. We have to decide very simply, is Islam part of human civilization? And that's my last sentence. When we consider that the basic principle of Islam and Islamic law is that the Prophet has come to the world to spread mercy on earth, rahmah. That's a very core concept they are promoting. And if we are saying, okay, rahmah, the extremists say it's only for Muslims, but we are saying it's for everybody on earth. Okay, just follow it. And that's very easily, everything is emerging from this basic principle. And if we accept our fellow humans, great, let's do it. Simply, we have to do it. We are a multi-religious, multicultural country. Okay, what can we do? If we try to accept the nation state as a framework, we can't follow a kind of policies who may explode this nation state, building fancy stuff like the caliphate or something else. We don't need it. We do have a republic, a more or less democratic republic. But okay. Now we are doing. We are about to publish a book about this tendency of the NU that's called Humanitarian Islam. That's humanistic view of Islam, and it's promoted by this world's largest organization, and even by the chairman. Now, last week he has been speaking to the European External Action Service activities. Action or activities?
Action Service.
Action. Action Service. Sorry, forgetting all this stuff. I know the abbreviation. That's good for me. Okay, and maybe there are questions.
Thanks a lot. Thank you. Rüdiger, thanks a lot. So there was a lot about evolving bodies of law and how different kinds of bodies of law affect one another. I'm not gonna start now a big discussion myself because I see a lot of interest on your side. So you can ask questions, and since I anticipate quite a few questions, always gonna do we want to always cluster 3 questions at a time. Mm-hmm. Okay. So who wants to go first? Yeah, I knew it. Maybe Wallace first, because he's right there. Yes.
So first of all, thank you. Thank you for the wonderful presentation of in the cultural dimension of international law, especially we focus on the Islamic traditions. So my name is Wallace, and I'm the Master student here at the DA, and then my question is also relating to Islamic traditions. So according to Quran, when there is an unlawful sexual activities, or we call it the zina, if I pronounce it correctly, there is a stoning penalties. So, but this stoning penalty violates the universal human rights. So, according to the United Nations Human Rights Committee stated in the General Comment 36 that the death penalty may not be imposed in any circumstance for conduct protected by international law, including adultery and homosexuality. But the Muslim or the Muslim people might say that hate is our traditions, or the stoning penalty is our traditions. So you cannot implement your own values or twist the meaning of Quran. So in this situation, will you see it violate, as you mentioned, about the principles of non-interference, or will these actions or human rights implement this by saying that you cannot by saying a kind of like delete or maybe erasing these stoning penalties might violate the non-interference principles as the UN interfered the Islamic traditions. Yeah.
Thank you. And there were more hands. Yeah.
Hi, my name is Svetoslava. I'm a second year my students here and also signed up as a discussant for today's talk. Thank you so much for your insights. They're very, very interesting for me. My question is maybe directed towards Professor Lohlker. I got the chance to spend 6 months in Indonesia as an exchange student, so I definitely maybe can understand a bit more your perspective on the religious side within the political situation of Indonesia. But something that really struck me was the question of Aceh Banda. This is the autonomous region of Aceh Banda. It's a region that basically allows for Sharia law to be implemented, especially for criminal cases. And I was wondering if you could comment on that and whether you would consider the decision of the Indonesian government to allow that status of Aceh to exist as a compromise to keep that unity in diversity, Or would you say that there might be a slight change in direction of the political and religious identity of Indonesia in the future? Thank you.
Thank you. And then we can do one more question in the first round, and again the neighbor next to her. The neighbor next.
Hi, my name is Julia. I'm also a second-year MI student, and I was just wondering how, like, talking about bringing together different cultures and the universalist character of human rights, how in practice you would go about reaching consensus without risking too much fragmentation. Are there any strategies to kind of find a compromise between those two?
Thank you. There were 3 questions. Maybe we're just going to go in the order in which you presented, and you can choose whatever question you want to deal with. Irmgard, then we go first.
So consensus, what are compromise? Okay. Okay, for the first, stoning, penalty for adultery or some other very hard corporal punishments, which are some part of Sharia. So it is important to understand several things. That Sharia has also several branches of law, like we have in our law, family law, and then criminal law is different. So different branches of law, family law, family relations, and then public law, so to say, which includes criminal law. So the state punishes. It's not relation between private peoples like marriage and so, but like the state takes punishment or rules. And in Muslim states usually make a big difference between the two. And so the vast majority of Muslim countries, out of these OIC member countries, for example, do apply private Muslim family law, for example. So they say we apply it, it's our private law, but not criminal law. So that's a big exception, and only less than a handful states apply a criminal Islamic law. And this is Iran and Saudi Arabia, because they do not really distinguish state law and Islamic law. They say it's all the same. But and then perhaps provinces like Aceh, but it's really a very, very small minority. I mean, they are important states and the leading nations in the Islamic world. But so many, Egypt, and you name it, they say no. Well, criminal law, we have a statutory law. The Islamic criminal law allows that. So they have different types of criminal penalties, and it allows within Sharia that the ruler, which is the state, establish a codified criminal law with the normal sort of penalties, normal crimes, and only the handful of Sharia and crimes against the God and against the religion are exempted from that. But otherwise, the main body of criminal law is not Sharia law. So so that must be really understood. And so you would find a lot of allies amongst the Muslim countries that criminal Sharia law should not be applied. And the decision is taken at the level of states. You said nation states, but states, we know them. We are organized. Our contemporary international community is organized on the basis of states with identifiable borders and sovereignty. And so the state has the right and duty to decide on the law which is applicable. So this is really the constituency to decide which law we take and we abolish, we change. So in the end, the responsible entity is always, as we have it today, the state. And it's not Islam and Muslims or some Muslim communities or whatever. We talk about states and the responsibility, and then they have also to take critical reports from human rights committees or so they have to justify what they do and what they don't. So I think maybe this helps, because this is also helpful for within the countries, in Iran perhaps, in Saudi Arabia, to say, well, we can be Muslims and still not accept Islamic Sharia law as in corporal punishment. So we need to understand that. I hope this is a bit helpful. And then consensus or compromise was the question here. What I currently see that we have already today quite a significant body of international human rights law, so covenants. I think it's about 10 core international conventions on human rights, and they have already, let's say, been adopted in a process within the United Nations. And so the status is now they are there, and states can only, so to say, decide to take them or not, or to take them with reservations. So currently I do not see any further process of future development of new human rights treaties. Yeah? Actually, was this the question? We don't need them as we see it, because we have already really a full portfolio of including then migrant workers' rights and convention on the rights of a person with disabilities and against disappearances. So I would say that we have, this body is quite comprehensive. But what is now the challenge is compliance, monitoring compliance, and improving the mechanisms and tools which are already there, that states accept them. For example, what for me, also in my table which I made, is important to look whether states have accepted the individual complaints procedure. Most of, if not all of the Muslim states have not accepted individual complaints procedure, meaning that one person which feels there was an infringement of his or her human rights can complain to an international body. Currently, they have only accepted reporting procedures, or they report regularly on the implementation, and they are challenged by the supervising committee, which is a committee of independent experts for each treaty. So for them, that's sufficient to report and to be challenged, but not in individual cases. So the next step, as we see it in Europe, all European states have, accepted for example, the Strasbourg Court, which contains individual complaints procedures. And this is then really the protection of individual against its own state. And that's the very new concept of human rights. That is not the state responsible for protection and that's it, but the individual has protection from international law against the state. But these are the challenges, not so much the formulation of a consensus document. I hope I understood the question. And the second is for you, I think.
The second question was probably yours, yeah.
At least, okay, Aceh. But Aceh, okay, there's a long history of Aceh. It has been whatever the Indonesian place to link to Mecca. It's historically speaking, but it's today the central government has a certain problem. Due to Indonesian law, we do have the right for the provinces to decide on their own which law to apply. And believe me, Jakarta, the government in Jakarta was not happy about Aceh establishing what they call Sharia law. It's a little bit different. I think it's not symptomatic for the Indonesian situation at all. Mm-hmm. We do have this kind of, you have to adopt a saying of one friend from Singapore. He said it's about a battle for the soul of Islam, but we do have a battle for the soul of Indonesia. But nowadays it's a little bit complicated. Remember, Indonesia, end of 1980s, was a dictatorship. And we had a transformation to democracy. It took around the 1990s. It took a long time to be more or less democratic. But at least there is this prerogative to provincial governments to decide. And we know in Aceh, in the 1950s, there has been a militant movement pro-foreign Islamic state of Indonesia. They were at least terrorists, more or less. They were fighting militarily against the Republic of Indonesia. And that's a long tradition in this province to have a very peculiar mindset of what is to be regarded as Islamic. It's different in other parts of Indonesia. Okay, Aceh is another. It's not Java, the main island, another island. That's a certain problem we have. But as far as I know, and still a limited knowledge after many years, after 2 days in Indonesia, we do have many Indonesia experts. I've been over there many times, and I have to admit I understand less than I ever thought. At least we do have this in the current transformation of the idea of what is Islamic, Indonesian style Islam. That's different from Aceh style Islam. And we have to see what's happening. I won't know what's happening in Aceh. I was invited in December to speak at a conference over there, but okay, sometimes I'm very conservative. It's family time around Christmas. I didn't go over there. But at least, hopefully, sometimes I will be there and ask around what's really happening. We do have very large, important Indonesian institutions, like the Majelis Ulama in Indonesia, let's say the Council of Indonesian Islamic Scholars, but they are not representative at all. It's a very conservative tendency. And we do have the other tendencies, okay, splitting a little bit this kind of Indonesian consensus. So, okay, I don't know what it's. I would love to have Aceh kind of being again. One time I have been there, end of the 1980s, and was very liberal at that time. But we could talk about Turkish influence after the tsunami. The Turkish government was supporting the reconstruction efforts, but not only building efforts, but only building a new Islamic idea of Islam. And that's very special AKP, Islam. That's a little bit different. And there are certain influences. We do have this battle of Islam globally, and Turkey is a key player in this field. But I prefer to look at interesting Indonesian players. Okay, I'm a little bit old by now, but I'm still optimistic. I'm not pessimistic. Okay, let's see. But Aceh changing again, hopefully. And stoning. Okay, don't use the Quran as a point of reference. I'm a scholar of Islamic studies. It's not a law book. You don't have to abide. Muslims have struggled for hundreds of years to interpret the Quran, and the only, leaving aside Saudi Arabia and Iran, the only Muslim organization who applied stoning in the last 2 decades was the Islamic State, ISIS. They applied it, and they filmed it. Very cruel videos they promoted, and we showed it once in Indonesia, and the scholars over there, they were shocked. Maybe even more shocked than seeing a video when cigarettes were burned. Ulama in Indonesia, scholars, love to smoke, and they were really shocked to see smoke. Okay, they are burning cigarettes. They had to take a cigarette immediately afterwards. And the same, it's about, okay, killing a guy by presumably being a homosexual guy by throwing him down from a large building. Okay, it exists, you can watch it. But they didn't believe. It's a fake, isn't it? It can't be Islamic. Don't refer to Quran to legitimize anything. You have to refer to the history of interpretation of Quran to understand it. Just quoting Quran, that's what fundamentalists are doing. And I have to admit, I once canceled the supervision of a PhD student because she said, oh, but the Quran says that, but you are doing your dissertation in Islamic studies, and we are not arguing the Quran is saying it. That's theology. Okay, you may say, I won't ever say it's Islamic, whatever. I can't say. I'm not even not allowed to say by my profession as a scholar of Islamic studies, religious studies. We are not talking about religious truth. That's theology. Okay, I'm the wrong person to answer it. I would like to say, okay, there is a tradition reaching up to the 20th century, but there are many other traditions. And don't think what the Quran is saying it. That's not the only argument we have. I may quote dozens of commentators on the Quran who say something contrary to these opinions who legitimize stoning. They say, okay, it's a very extraordinary situation in early Islamic times. We've had a lot. Okay, but I prefer saying that the Prophet is bringing mercy to the earth. That's not stones. You are stoning, for instance, during the Hajj in Mecca, you are stoning the devil, the Satan. That's what they are doing. That's the station where you are applying stoning. Many Muslims do that at that moment close to Mecca, only at that time. Whatever the Saudis doing outside of Mecca, we're leaving it aside. Maybe. And I forgot something. Whatever.
It's okay.
Sorry. The consensus.
The consensus, yeah. Do you wanna
okay, very short one. I think it's what I tried to describe is these Indonesians are trying to join the international consensus, and they are starting to apply whatever is needed to abide to the international consensus of international law. And I think that's the most important part.
Thank you. And we're going to move to the third round, and this time I'm going to privilege this side. So we're going to do 1, 2, 3. The third row. Third row. 1, 2, 3. Yeah.
The first row is discriminated against.
Yes, but not for long. I'm sorry.
Hi, my name is Erik Alholm. I'm a student from Finland. My question is, what is the right way of the international community to react to states that do not adhere to international law and human rights, such as with the Sharia law allowing for strict death penalty punishments? Thank you.
Thank you. And then just go down because there were 2 more in that.
The same line?
Yeah. The same row, okay. Yeah.
Thank you so much for being here with us tonight. My name is Thomas Turner, also a student here at the Academy. I would like to get back quickly to this comment you made on the Islamic associations of Islamic states, developing a counter-proposal for human rights covenants. What do you think is the larger implication of this towards fundamental international laws and principles, such as the UN Charter and human rights? Because after all, it is a consensus among nations, and if there is large momentum with a lot of nations that want to alter it, then that has certainly some implications on the current valid legislation. Thank you.
Thank you, and then your neighbor, yes.
Yes, my name is Rick Bosch, temporarily in Vienna from Oslo, Norway, and originally from the US. But not being a lawyer, I wanted to take this away from the academic to more practical example to make it easier to understand. Recently, in real world, the taking of the hostages in Israel. 1, is that a violation of international law? 2, what mechanisms kick in this process, in this event? And 3, what courses of action take place or do not take place, and why?
Thank you, and I'm going to hand over to our lawyer straight away.
So first, the first question, how should states react against human rights violations? What the system of the UN provides, there's a formal system of monitoring human rights in the Geneva, let's say Geneva setting, so your Office of Human Rights, of the High Commission of Human Rights, and there is for every single treaty a special independent committee, and this is one strand, and then there is the Human Rights Council, which is much more politicized because they are not independent experts, but they are governmental representatives. So there are monitoring bodies within the United Nations, and they have their own function of really documenting, let's say, the reports, and you have shadow reports, and then you have questions of the committee, to challenge the government, and have this process of reports and questioning, and this is very transparent. So I just invite you to go to the website and look, so really what's happening, a collection of facts and opinions and justifications. But does this really help? Does this really change anything? Well, international law works a lot, and this is then a connection to politics and international relations, with blaming and shaming. I think that's one of, it's not always, the arms, which fortunately, which talk, but while you have a certain reputation at the international level, and you also want to pursue your goals in economic terms, political terms, alliances, and so on. States traditionally and generally, and I see that, and you can observe it in the United Nations here, when you have the chance to go to any conference or so, which is there, are very careful to have a good reputation, to not be blamed publicly for any wrongdoing. And if they are very, sensitive, and they react, and then it's a platform of discourse, and this is already a lot, because without the United Nations mechanisms, you would not have that platform. And how should states then react? Then further to that, so once you know what's happening and what's in public domain, so to say, that every single state should or could react. And under the idea of international law is that states have the possibility, in particular, if a state violates an international obligation, to take countermeasures, but countermeasures are always without military force. So they have to think what other countermeasures we can take, with the exception of the use of force. So they have the right to sanctions, economic sanctions, or even the violation of treaties, if that's justified by the previous wrongdoing of the other state. So the states themselves are called to monitor compliance and take enforcement actions generally. So it's a horizontal system of law, which where the sanctions are then imposed by other states as well. Only in a few cases of the threat to peace, international security, the United Nations Security Council is a centralized organ which can then, make centralized sanctions. But otherwise, every state is called upon to react. Or a regional group like the European Union, for example. It also can make sanctions against a state which is violating international law, human rights, whatever. So that it's really upon the states themselves and to decide on their own behalf or in another organization, in the region or even in the United Nations. So that would be my first reaction. Then OIC counter proposal to you, and what is the effect to have a counter proposal? Good question. You could first say, is that really necessary, and doesn't it undermine the universality of the Declaration of Human Rights? Why do you need that? On the other hand, we are aware that we have regional human rights documents as well. So we agree that the European Convention on Human Rights has its sense, has its purpose for the European countries. They have specific common heritage, common culture, common culture, history. So they have perhaps an understanding which is different than in Africa or so, in particular when it comes to monitoring compliance. So it's interesting that this text, we have African regional human rights documents, Inter-American Court of Human Rights, we have African Court of Human Rights. We do not have yet the Arab Court of Human Rights, even though the statute is already there, but it's not yet in force. So the idea could be that it's reinforcing a better compliance, better monitoring, because then the organs are sensitive to the regional problems. So when I talked about limitations and restrictions, for example, of the exercise of the right, every single right is actually limited. No, the right of freedom of expression, you cannot defame, act in a defamation manner, so this must be restricted. You cannot tell lies about somebody else, who is then damaged. So the court has to decide you must not do that. You get even a punishment if you say something wrong which is damaging the economic, for example, forthcoming of a person. So there is a watchdog, so to say, a watching tool that the human rights are exercised in a way that it doesn't hurt and harm others, or public goods like peace and also public order. So this is the possibility to, and this is to inline perhaps universal human rights to regional specificities. And whether the Islamic declaration is doing that or not it can be discussed. On its face, it is not in contravention to the Universal Declaration of Human Rights, because it really follows the scheme of the individual being in the main focus, which is one of the concepts of human rights. We're talking about the rights of individuals and not rights of states or others. So this concept is here. So rights of individuals, then dignity of individuals, and then if you say, well, the problematic thing is that who decides how the limitation under Islamic Sharia is exercised. And this brings us again to the question, who decides on the infringement or not. And again, we are to the monitoring body. So if they don't have a real monitoring body which is independent, it's probably not more than a document to a declaration, as it is a declaration which shows that there is a possibility of bringing together human rights and Islam, because there are a lot of scholars and also political strands that say there is an alignment, and we have interpretations of Islam that allow alignment, and others say, well, the exceptions are more important. But I think I would rather see it as a positive attempt to reconcile human rights and Islam. So because then you put it to the implementation, and there you can do a lot of positive work, of also of development, liberal movements to say, well, you see in the Islamic Declaration of Human Rights, we have the right to marriage or right to freedom of religion even, so then it's not a contradiction per se. But you can, of course, criticize it, but it's, they are there, and they are quite, they are quite famous or well-known, because these two organizations are quite influential. The OIC and Arab League are, prominent organizations. Whether their human rights documents and instruments are very prominent or have an effect is a different question. So in reality, does really the League of Arab States care a lot about compliance with the Arab Charter on Human Rights, or do they have other priorities? So that can be questioned. Also, the OIC, Independent Human Rights Commission, do they really take it as in a very prominent role, the individual human rights, or rather Muslim rights vis-a-vis the West, which in the recent press releases of the OIC, Independent Human Rights Commission, are rather making fierce declarations against Gaza, of course. No, they say press release of December the highlights, International Human Rights Day of 2024 highlights the double standards in upholding human rights norms across the world and calls for justice for the Palestinians by ending the impunity of the Israeli occupation forces for its well-documented war crimes in Gaza. So this was one press release of the OIC, Independent Human Rights Commission. So that's what they now focus a lot on. Yeah, and the next question is, taking hostages in Israel is somehow connected to that. What are the reactions? I mean, you can follow the media. What are the reactions? The political reactions are there, and they try to negotiate. I mean, what can I say more than what we know from the media? Taking hostage. What is here? What your question is? Taking hostages in Israel. So this concerns a group of terrorists who take hostages. So they are criminals. So under my understanding of law, they are criminals. They need to be brought to court, to a criminal court, and bring to jail. Okay, but which jail? Where is there a functioning system in Palestine, in Gaza, that exercises this jurisdiction? Because it's not a state act as such. There is not a government which did these acts. It's a terrorist group. So this and it's recognized as such. But there is no court in Gaza which can bring the terrorists to justice currently. Perhaps in the peace process, this will be one of the consequences, that the perpetrators need to be brought to justice, to court. But there is a long way when you have such a non-functioning state and non-functioning institutions in various areas in the world. That's one of the challenging things, that the lack of institutions that work. So this is really fundamental for protection of human rights and also then bringing perpetrators to justice.
Irmgard, thank you. Rüdiger.
Should turn it on. At least, okay, taking up the cue from Gaza, the hostages. We've had a very recent, I think in November, it was issued a declaration by the R20 Secretariat called, I have to quote, analysis and call to action, which is intended to spur the creation of the Road Not Yet Taken initiative, a multi-religious path towards Middle East peace. Okay, that's an initiative by the NU, once again, and they are saying, okay, we do have this there is a political problem, not a religious problem. We have to take religion out of it. It even applies to Hamas, claiming to be Islamic. We are not interested. Gaza and Israel and West Bank, we do have a lot of political problems. We have to solve them. And we have to, that's circulating in these circles, we have to, let's say, transform a religion into part of the solution, not as a problem, not as part of the problem. Okay, take whatever Islam, the Jewish positions, whatever the right-wing settlers' position, that's has to be taken out. The members of the R20 who were supporting this declaration, there were some Jewish scholars amongst them, some Christian and some Islamic scholars. Okay, that may be a solution, but the solution has to come out of the political process, simply. And you can't really solve it from an Islamic point of view. Maybe it's helpful to delegitimize extremist Islamic positions like Hamas. Just tries to project it as a general solution for the problems of the Islamic world, and that allows me to turn to the OSCE. I think the OSCE is not representative at all for the Islamic world. And I'm not talking about governments. I'm talking about Muslims all over the world. Very few people respect OIC decisions. Most of them don't know anything about it and are not interested. Even that, and it has been for OIC, the organization, the institution has been for a long time dominated by Saudi positions, and they have been, has been instrumental for Saudi, and that's turning to one of my focus of research for Islamic Saudi Arabian soft power diplomacy. They are trying to project the idea, at least of Saudi Arabian Islam, the Wahhabi brand of Islam. It has been changing for several years now, but OIC was instrumental to project this idea of extremist fundamentalist Islam worldwide. Okay, it doesn't work not as easy as before by now, because of changes in the Saudi Arabian government. I think it's okay. I've read the declaration, the counter-declaration at all, but nobody outside of Saudi Arabia and OIC circles is really reading it. It's part of the political game, what I just mentioned before, the battle for the soul of Islam. Some people are throwing, okay, we do have this counter-declarations of this detrimental Western influence to get rid of it, but nobody's really interested. Not at all. As far as I know, even in Tunis, whatever, in Egypt, nobody. Okay, there's these guys over there in Saudi Arabia declaring whatever. I have to buy food for my family, not reading these these kind of declarations. Think of Lebanon. We don't have a government. There is no government that could abide to any declaration at all. Okay, it's really a very, let's say, systematic approach to systematic develop the systematic counterpositions. For Muslims, it's not at all interesting, I have to admit. Maybe some guys in Pakistan who are very happy to go to demonstrate in the streets against whatever, or pro-blasphemy law, or what's against human rights. Certainly, I've been talking to a colleague, a friend of mine, who was threatened, if you are talking in Pakistan publicly, you will be called blasphemous and you will be persecuted. A guy from the US, Turkish origin, Muslim, okay, he said, no, okay, I will talk and leave the country after this talk. That's secure, more secure than anything else. We do have these problems. Some countries are affected, especially like Pakistan, like partially Saudi Arabia, Iran. But if you're going and just asking around in the streets in Tehran, who should the Iranian government abide to this declaration or counter-declaration? Which one? We don't have, that's not part of our problems. We do have other problems. We shouldn't overstate the influence of these declarations. It's very fine for conferences, anything else, but the OIC is a government enterprise with selected religious scholars, and that's quite simple.
It would be tempting now to go on about, I mean, with the two of you and obviously with you, but we've run out of time. I'm really sorry about this. I understand that there are quite a few people who want to ask questions, so those, please come and hijack one of the one of the two speakers and then talk on a bilateral basis. Was a fascinating conversation, I thought. Yeah, so culture meeting law and law meeting culture, and there's there's a lot of entanglements between them, which have all kinds of political repercussions, all kind of cultural repercussions, all kind of legal repercussions. So thanks a lot for the speakers.
Thanks.
And
Thanks for inviting.
and thanks a lot to the audience for being here. Have a nice evening.
Thank you. Yes.